Welcome back to the show, ladies and gentlemen. This is Hannah Howard. I'm filling in for Paul Harrell one last day while he's on vacation, and this is Conduit News. We have with us Robert Steinbuck. He's a professor at the University of Arkansas at Little Rock Law School. Thanks for being with us.
Oh, it's always my pleasure to be with you. And before we get started, let me just make clear that my views are mine alone and not necessarily of the school for which I work.
Absolutely. So you've got some really interesting research that you did a couple years ago into affirmative action. So explain to our listeners what affirmative action is.
Yeah, it's a really great question, Hannah, because it's not even clear these days what is affirmative action. The definition started out as essentially saying when you have two equal candidates applying for a job or applying for a spot in school, you'd put the thumb slightly on the scale of the minority to reflect the historical discrimination that took place. But these days, quite often, what had been called affirmative action is now race-based admissions, meaning race becomes a nearly dispositive factor in admissions. And so that's not a thumb on the scale, that's a brick or a block on the scale. And that's where we start to see some problems. For example, in one very large group of data that I examined, it was somewhere around 750 students. Almost 3/4 of the African American admittees were in the bottom quarter of the class, meaning that and in terms of their measures on the LSAT. And so you let in students of a particular group who all have, not all, excuse me, who 75% of which are in the bottom of the class. And then what happens on the back end? We see a bar passage rate for whites well over 80%. So that's, or I think roughly 80%. So that's a 20% failure rate, of course. And you see the African American cohort group with a bar failure rate twice that of the white students. And so it should not necessarily be a surprise that when you have a group on average that comes in with lower credentials, that their output reflects that in many respects. Now let me be clear. That doesn't mean that a minority student hasn't been or can't be admitted and then graduate at the top of the class and pass the bar. All of those things have happened. But I'm talking about the group on a whole, or the group on average. They roughly reflect the same idea. And the group overall is being harmed, I believe, because we're letting in people with relatively low admission metrics and not telling them that they have a much higher risk of failing the bar than people who are admitted with higher metrics. There was a recent paper or call for investigation, I should say, by a professor, by a judge in California who wants to conduct a study why there are so few minority law clerks. And as you know, but your audience may not know, law clerk sounds like an unimportant position. It's actually a very important position, coveted by graduates from law school. It's the position in which a young lawyer works for a judge and helps write legal opinions. And it can really shape a future lawyer's career. And there is a disparity in the number of minorities who are getting these jobs relative to non-minorities. But then if you look at the same data set that I was talking about earlier, you will notice that if you want to look at the top quarter of the class, right, those who graduated with a GPA in the top 25%. And remember, top 25% isn't necessarily that high, right? We kind of think, I'd love to be in the top 10%. I'd love to be in the top 10 students. So top 25% is not super high, but you would expect judges want sort of the best and the brightest from whatever school it may be. So they're going to look at the top 10%, the top 20%, the top 25%. And so if you look at the top 25%, it's roughly 1% from this group of 750 students that were African American. 1% of the African American group made it into the top 25%. And so it's not surprising, therefore, that we see nationally a low number of law clerks who are minority because of this phenomenon. And this phenomenon is known as the mismatch phenomenon, where students are admitted with low metrics and then they struggle in whatever school they're at versus being admitted to a school where they fit more in the middle, and then they would do better and they would have a much higher percentage in the top quarter, top 20, top 10% of the class, and they would get more placements perhaps in law clerk positions, although it's not the only factor, right? Because the judges are also looking at what school the students graduate, so there is a tension there. But nonetheless, if you can't get into the top 25%, it's very hard, regardless of the school that you're at, to get a job at a clerkship. So this is the sort of dynamic. With all that said, no one is contending, and so that obviously includes me, that the only thing that should be considered in admissions are LSAT scores and undergraduate GPA. And the only thing that people should consider in graduating law students is their GPA. But these are important metrics. And indeed, they're probably the most important metrics. And so when you hear some suggest, well, we shouldn't look at the LSATs. Okay, what else you got? What do you got in the alternative? And that's when you tend to hear mumbling and non-answers. Well, we should look at leadership skills and other intangibles like that. Okay, how are you going to do that? Do you have a scale? People step on it and tells you their leadership skills. You look at their membership in clubs. That's fine. We do that already. We don't admit students based solely on their LSAT scores. We don't admit students solely based on their undergraduate GPA. Judges don't hire law clerks solely based on their law school GPAs. But yet, we see this disparity, for example, in the number of law clerks. So it reflects the fact that those are important metrics, and they will remain important metrics. This is a real challenge that we have. The race-based admissions that we see across this country too often are harming the very students they are intended to help. And that's a problem with feel-good politics in general. We should be adopting policies that help the students, help those who have struggled, help who have suffered discrimination directly or have suffered from the effects of discrimination that has taken place across this country historically. And those are real phenomena. But the policies that we have in place today, I not only fear, but I know in many respects are actually harming people. And so if you can get beyond the rhetoric, if you can get beyond what the left now is their go-to move, Hannah, right? You know what the go-to move for the left is. If you oppose any leftist policy, you're an ist. You're a racist, you're a misogynist, homophobe. I realize that ends in phobe, but we'll call it an ist as well, right? So all these things, this is the leftist knee-jerk reaction. It's, you're an ist. All right, well, do you want to have a conversation, or do you just want to pursue your policies? Luckily, thank goodness, we are rolling back some of these bad policies, and we are developing a meritocracy. You know that the mayor of New York City, Bill de Blasio, has been moving to eliminate merit-based admissions to the specialty schools. Why? Because the distribution of social groups or racial groups, meaning how many Hispanics, how many African Americans, how many whites, how many Asians are in that school, don't reflect directly or even indeed particularly closely the representation in the New York City population. And my response is, so what? So what? Now, if it's a function of discrimination, then we have an issue. So if he was merely saying, well, we've got to investigate discrimination, very good, I'm on board, I'll help you do it. But that's not what he's saying. He's saying that the outcome needs to mirror the percentage in the population. Why? Why? There's so many factors that go into admissions. Maybe someone doesn't want to go to that school. Maybe, on average, some groups want to go to the specialty schools more than other schools. I don't know. But the knee-jerk reaction that it must be racism is actually proven false. And the outcome-based policies are bad all around. They're bad for the people that are kept out, and they're often, albeit not always, bad for the people that are let in. So I realize my answer was rather long-winded to your simple question, but it's a complicated problem.
Well, it was long-winded but comprehensive, and so that's important. So, you mentioned, you're a conservative white male, so you're automatically the bad guy. And so now you want to start talking about races. I mean, absolutely, you become labeled with the ists. So what kind of pushback have you received by this, or what kind of labeling as the bad guy have you gotten?
Oh, well, I'm sure it's out there, right? I'm sure that people are saying bad things. I've heard a little bit of it, but I largely ignore it. Here's the thing. You can call all the names you want. My response is, what else you got? Okay, you done with the name calling? Are you finished with that? Have you graduated from second grade? Now, what else you got? You want to have a discussion about the stuff? You have any data? Oh, no data. That's troublesome. Oh, what data do you have? Oh, that data? No, you don't understand the data. Oh, okay, you don't want to discuss that then? Okay, I'll give you one example. There was one person who was making these claims about the relationship between the LSAT score and bar passage, and he started to talk about something in statistics that's known as the R-squared value. And then he goes, oh, well, this, and therefore the conclusion is that the LSAT score only predicts, I think he said something like 7% of the outcome on the bar exam, which, by the way, is not a terrible number, and we'll talk about that in a moment. But he's just wrong on the math. R-squared doesn't work when you have a continuous variable on one side and a binary variable on the other hand, on the other side. So it's another example of just pure ignorance when it comes to basic statistics, and yet every Tom, Dick, and Harry will fancy himself an expert because he read a Reader's Digest version of how statistics work. And so the fact is, we know that there is a pretty good relationship between LSAT scores and bar passage. There's an even better relationship, by the way, between law school grades and bar passage. Of course there are, right? Because bar passage measures essentially the same thing as the stuff we do on final exams in law school. So I agree that's a better measure, but it's hard to use someone's law school GPA as a basis to decide whether to admit that student to law school, unless you have a time machine, of course. But mine broke, so I can't use that anymore. So LSAT is the best pre-law school measure that we have to determine success on the bar exam. Let's say it were only 7%. Let's just assume that to be the case. That's just the basis for that claim is nonsense. It's ignorance, frankly. But let's assume that we're true. What else you got that's better? So I'm not saying you rely solely on that. You shouldn't rely solely on that. I would never rely solely on that. But what else that you got that's better? And when they are unable to give you something that's better, the response is, all right, well then let's look at that and let's look at what else you're relying on. And if the rest of what you're relying on are factors that are irrelevant, and they may not be, right? What school did the other person get? Of course, the undergraduate GPA is the second best factor, I would posit. And we do look at that quite closely. How active the person is in various organizations is somewhat helpful, but this is one of those areas in which the left likes to posit that as an important predictor. It's not great, I got to tell you. It's not great. And then, of course, they will interject things like race, sometimes gender, and those are not particularly good predictors at all. And so they say, well, there's been a discrimination historically. That's 100% true. How does that relate to whether or not someone is able to pass the bar? If an individual suffers some adversity, and it can be discrimination, it could be the loss of a parent just before taking the LSAT exam, or some great trauma during college that depressed the student's GPA. All of those are relevant to suggest that those metrics for that individual don't accurately reflect that person's actual potential to pass the bar. And that, I think, is legitimate to look at. But that's not how we use race-based admissions. We look at race, and then we essentially bump up the scores accordingly. Not literally, to be clear, not literally, but if you are a minority and you have a certain set of scores, there's a very high likelihood that you'll get into any given law school when compared to, say, whites with those same scores, and there's a very low likelihood that those whites will get into law school. And so the result is that all of those people with those same set of scores, white, black, Hispanic, Asian, perform the same way. But the difference is the overwhelming body of whites in any given law school is above that metric, and that's not the case for minorities, in particular African American minorities. And so you have a cohort that suffers, and that if that cohort was spread out more evenly amongst other schools with comparable incoming metrics, they would perform not only as well as any other person at that school, which they of course would, but they wouldn't suffer the additional depression in their performance by being at the very bottom or near bottom. By very bottom, I mean bottom quartile of any given class. And again, it's only 75% of those African Americans in the cohort that I analyzed, but that's big. So the other 25% don't suffer from this problem. But that's a small number, and as I said, in that same group, slightly over 1% of the African Americans graduated with a GPA in the top 25%. So you see how the group as a whole, or I should say more accurately, on average, suffers from what is essentially race-based admissions. And by that, I don't mean race is the only factor, but it's an extremely heavily weighted factor, and that's actually harming the group that it's designed to help.
So the big takeaway from this, you've actually done the studies, you've collected the data, so, you know, you're not making an emotional claim, you're making a factual claim. But getting those facts has not been the easiest time for you. So explain your battle with that.
Yeah, I've sought these records, and I'm not the only one to do this, and this happens across the country. In fact, I've sought these records pursuant to the Freedom of Information Act, and I've had some challenges in doing so. The first time I sought the records, I was told no, and then we got an Attorney General opinion, and then they turned over those records. Second time I sought the records, they just turned them over to their credit, and I got those records. And then the third time I requested those records, they said, we can't give them to you. And I said, what about the last two times? And they said, well, the first time was okay, but the second time we broke the law. Okay, that's a curious defense to not turning them over the third time. And then we eventually got the vast majority of those records, the key parts of those records, as part of a settlement. And in fact, we're trying to get attorney's fees as a consequence of that, although they are resisting the attorney's fees motion on the grounds that we didn't get everything, or at least we didn't get enough. We believe we got substantial compliance, and they claim otherwise. So we'll see how that plays out.
So, and what's interesting about that whole thing is you've written a book on the Freedom of Information Act. So I think that you know what you're talking about when you say, yes, in fact, state institution, I do deserve these records, I am entitled to them, and they still won't hand them over.
Oh, I have been routinely ignored by various state entities throughout Arkansas when I've made clear what the law says, to the extent that they have been interested in pursuing an alternative outcome. And I dare say that many times I have been proven right. And of course, as you say, I'm a co-author of the treatise on the Arkansas Freedom of Information Act. In fact, I've had the Supreme Court of Arkansas routinely cites to my book. Now, just to be fair, I'm the third co-author, meaning I wasn't on the previous versions, and the Supreme Court has cited to both the previous versions and the current versions. So I can't take credit for the previous versions, but I'm the co-author on most recent version, and the Supreme Court has cited to my version, the one I'm on, as well, as has the Attorney General, and it's the go-to source, of course, on the Arkansas Freedom of Information Act. And so when I have people tell me what the law is, that's their statement, and it's inconsistent with my understanding as reflected in my book, I tend to think that maybe they are either not fully informed or they are clouded by the preferred outcome. For example, I think when it comes to across the country, by the way, this has nothing to do individually with my case, but across the country, I think we have seen resistance in whatever entity houses data on admissions, and there's a well-known case now out of California brought by this professor at UCLA, Rick Sander, who I have worked with on an article. He sought data from the from the California bar, and they resisted turning it over as well. And I think this resistance that we see across the country is largely reflective of a leftist political ideology of continuing to pursue these race-based admissions programs in which the proponents believe that outcomes should reflect percentages in the population generally, be it meaning law schools should admit people consistent with their respective representation in the population. Lawyers should produce those outcomes. The bar should pass in those outcomes. I agree with the latter two. The problem is when you engage in the first one, where you force populations in law schools to mirror the individual populations throughout the country or in the state, you wind up with the problem that we have been discussing, which is known as the mismatch problem. And that curtails the ability of minorities in particular to pass the bar at the same rate as non-minorities and to practice law at the same rate as non-minorities. So the actions by those pursuing race-based admissions is reducing the likelihood that you have minorities practicing law.
Absolutely. And so, no matter the kickback you get, you take it because it's in the best interest of those students, of the minority class. So, they can say what they want and they can think that you're against them, but you're really for them. And I think that's the biggest takeaway from it all. But I really appreciate you coming on with me. Just as a caveat, Steinbuck's actually my professor this year, and let me tell you, it's incredibly refreshing to have at least one conservative voice when I have now spent 6 years in higher education that I have not had a single one. So it's incredibly refreshing for you to at least share in my ideas and to be so vocal and to fight for them, quite frankly. And so I really appreciate you coming on with me, and I hope we can do it again.
I look forward to it. Thank you so much.
Okay, we'll be right back after this break.